insights, real-world experience, and forward-looking strategies. So each session will be followed with a brief Q&A. So if you're joining us virtually, please feel free to enter your questions into the chat. I'll be monitoring the chat throughout the sessions. And then for your own planning purposes, we'll be taking a break from 1:30 to 1:45. And then just some housekeeping. Following the session, we'll also have a fun trivia game called Kahoot, where you can answer some trivia questions about each session. When there's a QR code that appears on the screen, you can scan it on your phone to participate, and we'll be crowdsourcing some of the responses, and there'll be some fun little prizes, which you see up here. Just as a reminder, this will be the prizes will just be for in-person attendees only, unfortunately. But also a reminder that this event will be recorded and can be used for CLE credit. So without further ado, let's get right to it. Kicking us off is Amanda Johnston and Katy Herman with What's Brewing in Compliance, a session diving into hot topics and enforcement trends impacting FDA-regulated companies. If that doesn't work, you can use this one.
How do I turn it? Oh, there it goes. I said ope. Good afternoon. It's great to see everybody here in person and all the people online. Really appreciate you coming out. Like Daria said, the sun is actually out today, which is lovely. Katy and I are going to give kind of an update in a kind of a briefing style on some cases, some notable cases as of late in the fraud and abuse area. And then we'll leave some time for questions. All right. I guess we'll briefly introduce ourselves. Amanda Johnston, I'm a partner at Gardner Law. Been here for about 6 years. Before coming to the firm, I worked in-house at Coloplast, Medtronic, United Healthcare, in various compliance and regulatory roles. And here I split my practice between compliance and regulatory. And I'll let Katy give herself a brief introduction as well.
Yeah. My name is Katy Herman. I am an associate attorney with Gardner. I have been with the firm for about just over a year now. Prior to Gardner, I worked in-house at Coloplast, supporting in both legal compliance and also contracting functions in both the manufacturer side, but also their DME entity. And at Gardner, my focus is mainly on compliance.
All right. With that, we'll go over quickly just kind of the topics we're going to talk about today. We will do a brief overview or refresher on kind of the key fraud and abuse laws that we're going to be talking about. We'll talk about kind of last fiscal year from a DOJ perspective and what that False Claims Act recoveries and settlements looked like. And then we'll talk about going forward. So what are the DOJ priorities from a compliance, fraud, and abuse perspective? Where should companies be focusing? Also emerging themes. So again, kind of drawing from what we've seen so far and what we've seen in the past year to come up with some themes that will be emerging or are emerging. We'll do some case spotlights and then time for Q&A. All right, so just a quick refresher, primer. Really the two main fraud and abuse laws that we're going to be talking about today are the False Claims Act and the Anti-Kickback Statute. The federal versions we're going to be focusing on. So first, the False Claims Act, as we all probably know, again, it prohibits knowingly submitting false or fraudulent claims to the government. So it's broader than the healthcare industry. Some of the common themes that we see are theories of liability under the False Claims Act, off-label promotion, medically unnecessary billing, improper billing. Those are the themes that we'll see, and we'll see those in the case summaries as well. And then the Anti-Kickback Statute, which is a criminal statute, so it's a felony, and it prohibits the offering, giving, receiving of anything of value in exchange for referrals for services or products reimbursed by federal healthcare programs. And why these matter, and we'll see in some of the cases, these are used together. So these two statutes working together really are the focus of the DOJ. As it relates to sales practices, marketing strategies, and then financial relationships with HCPs. All right, so just quickly, you guys may have seen this, but in February, the DOJ released their summary of fiscal year 2024, their enforcement actions from False Claims Act perspective. Total settlements and judgments for fiscal year 2024 was $2.9 billion, and that was up slightly from the previous years. But really, what stands out here is the number of qui tam lawsuits that were filed last year. 979, that's the highest in history, and it's continuing to grow. This is a big area of income for the government. Total settlements and judgments since 1986 is $78 billion. And then the total cases resolved last year, 558, that's the second highest. So we've seen kind of a steady increase over the years. In my opinion, the most notable is just the continuing rise of qui tam lawsuits. All right, so then just what the DOJ is saying. So there's been a lot in the news over the last few months. There's been a lot of change, a lot of commentary made, but one thing that I think will not change is the DOJ's focus on the False Claims Act enforcement. So in a speech in February, they again reiterated that they will aggressively enforce the False Claims Act. As you can see on the previous slide, it's a big moneymaker for them. But also its principles align with the new administration's goals to reduce fraud, improve efficiency, and prevent fraud, waste, and abuse, and ensure accountability. Some of the emerging questions, again, I don't have answers to these, but it will be interesting to see if we see any DEI-related qui tam suits come up, or if we see any DEI-related, theories of liability coming to fruition. I haven't seen anything to date, but it will be interesting, DEI, but also if there's additional executive orders or focuses on different types of practices. So that's kind of an open question still. All right, so key themes, and this is kind of looking back, but also kind of predicting based on what we're seeing and what we're going to talk about today. False Claims Act enforcement it's apolitical. It's bipartisan. Generally, we've seen, everybody wants to root out fraud, waste, and abuse, and then they're making a lot of money in the settlements, and it's accelerating. Whistleblower activity, as I mentioned, is at an all-time high. So I only imagine that will increase. Mark and I were at a breakfast this morning, and we were talking to some attorneys in the space, and we were speculating whether there'll be more cases filed with the use of AI. Any whistleblower could go on to ChatGPT and draft up a complaint. So is that going to make an impact? Possibly. Commission-based rep models. So if you guys remember, there was a Mallory case. We're going to talk a little bit about kind of what's happened since that. But that's still kind of an area of enforcement, and I know that it's very common among medical device companies and pharma companies. So I think we will, continue to see scrutiny in that area. And kind of the garden variety, we're going to continue to see speaker programs, financial arrangements with HCPs. We are going to, we've seen actually an increase in kind of FDA-related safety, labeling, quality cases that have been prosecuted from a False Claims Act perspective. And we have a couple today that we'll talk about that were pretty recent. But that's interesting. We're seeing, again, not the FDA necessarily taking action, but it's being prosecuted from a False Claims Act perspective. And then we have some emerging areas, which we will talk about in the case summaries, but Medicare Advantage, telehealth, genetic testing, diagnostic testing. So these are kind of the themes that we are seeing based on last year's and kind of this upcoming year, fiscal year from a DOJ perspective. Now we will dive into some of the recent cases. And I'll pass it over to Katy to talk about, so we have kind of themes. Mm-hmm. The first theme or bucket is kickbacks and charitable foundations. And I'll let Katy take it away.
All right. So in our first bucket, our first case, as Amanda said, we'll go through this kind of brief style, but the first case is related to Teva Pharmaceuticals. So they agreed in a settlement with DOJ to pay $425 million for a copay kickback scheme. So the government alleged in this instance that Teva conspired with multiple third parties, including specialty pharmacies and two allegedly independent codependent or copay assistance foundations to direct support provided to the foundation directly to patients taking their MS drug, Copaxone. So from 2006 to 2017, they coordinated with the third parties to steer those donations while continuing to increase the cost of Copaxone by thousands of dollars. So the allegations allege violations of both the AKS and FCA. Key takeaways here are that the DOJ is targeting use of charitable foundations to mask kickbacks. Those Medicare copays that were being funded are truly intended as a cost control by Medicare, and they are not to be bypassed by pharma or medical device companies. And copay assistance has to be tied directly to, or copay assistance tied directly to prescription volume is an AKS risk.
And this one was one of the few that was not a key TAM, which is interesting.
Correct.
It was a DOJ-led.
And this was the largest copay assistance and charitable foundation settlement to date. This activity within copay assistance, the U.S. Attorney's Office has collected more than $1.4 billion just from this initiative alone.
Wow. All right.
All right, so next up, Pfizer has agreed to pay $60 million for Biohaven kickback allegations. So in this context, Biohaven, prior to acquisition by Pfizer, had engaged in activities alleged to induce prescriptions of their Nurtec OTD, their pharmaceutical product. The payments included honoraria, high-end meals, and repeat speaker programs where individuals were coming repeatedly to the same program, finding limited or no educational value, and also included individuals who had no need to join, such as spouses, colleagues, and other individuals. And the government alleged that all of these payments were made with an intent to induce prescribing behaviors. So the speaker programs in particular were a high value item and what the government focused on. The conduct did end when Pfizer acquired Biohaven and shut down the programs, but there was still settlement related to it. So takeaways include this reinforces DOJ scrutiny of speaker programs. We previously saw the OIG special alert on speaker programs, and DOJ is continuing to focus on these. And then reminder that intent matters. Educational value has to be genuine. It cannot be with the intent of marketing. You have to structure it, and the intent and the educational components have to be valid and bona fide.
All right, and this was a key TAM case.
Correct, and that the realtor actually received $8.4 million from her federal recovery.
Does it say if it was a sales rep or employee or anything?
It was an employee.
Okay.
I believe she was a sales rep.
Okay.
But to highlight the monetary incentives for key TAM relators as well.
Yep. And I just pause quickly. I was at a pharma conference or a compliance, it was the pharma compliance conference in the fall, and one of the speakers from the DOJ, or from the OIG actually, had said, watch for speaker program settlements, there's gonna be more coming, and then sure enough, we've seen a couple now. So we'll talk about this next one, which is a key TAM.
Yep, so again, DOJ targeting speaker programs, US v. Gilead. In this context, they were alleged to have paid more than $23 million in kickbacks via honoraria, meals, travel, to physicians for 17,000 plus speaker programs from 2011 to 2017. Again, we had instances of repeat attendees having little educational value, and these events were held in lavish venues such as the James Beard House, including multiple course meals, alcohol pairings, and travel perks. The government claimed that these events were often attended by people, again, repeatedly coming in and having little to no educational value, and therefore likely intended to induce the prescription of the products. The other of note, Gilead's compliance monitoring failed to detect or prevent abuse despite internal warnings. So in this context, the legal theories were AKS violation through the False Claims Act. Key takeaways here, DOJ continues, again, to target speaker programs as kickback vehicles, looking at and making sure that you have proper controls as to event venues and ensuring that everything is fair and balanced and fair and appropriate, and reinforces the need for robust monitoring on that fair market value and documentation of engagements with HCPs. All right. And then the last case in this bucket we're going to discuss, or set of cases, relates to commission-based reps and the legal landscape related to it. So as Amanda alluded to, the first case that we'll look at was Mallory. So the Fourth Circuit held that the volume-based pay to a 1099 or an independent contractor sales agent violates the AKS, and it is not permitted to fit within a safe harbor. But subsequent to that, in two separate cases, Sorensen in the Seventh Circuit and Marchetti in the Fifth Circuit, they determined that volume-based pay to independent sales reps is not automatically or is not per se illegal under AKS. They're really focusing on the intent and then whether or not those sales reps had the ability to influence or induce those individuals. So from a takeaway perspective, 1099 commissions have historically been risky. I think it will continue to be risky, but they are not inherently banned or not per se illegal. The key risk factors are going to be determining whether or not direct contact with the prescribers exists, whether or not they're acting on behalf of HCPs, and whether or not they're separately reimbursable items. We would also consider de-risking via policy limits and restructuring, and making sure that your contractors are being paid in a way that limits this risk.
Yeah, we routinely get questions about this because it's kind of a weird, environment in that so many startup companies have contractors that are sales reps. That's just, we can't afford to hire full-time employees right away. So we do get a lot of questions about this, and we, help them try to come up with an agreement or arrangement, whether it's, setting maybe less on commissions and more on like training targets or educational targets or that kind of a thing. But ideally, you want it to fit in within the personal services safe harbor, but it's hard. You can't do that if it's based on the volume and value. So still kind of up in the air, but we now have two separate circuits that have said it's not per se legal. So we'll keep an eye on that trend. All right, and then I'm going to talk a little bit about kind of the next bucket, which is off-label and safety risks. So the first case is Diopsis. So this is a medical device company out of Pennsylvania. This was brought as a qui tam lawsuit actually from an ophthalmologist, so Dr. Jane. Diopsis has a vision testing system, NOVA, and it is cleared by the FDA for visual evoked potential testing, VEP testing. And that is when they put electrodes on your brain and they show like your eyes certain stimulus, and then they measure the detection of or how your brain kind of lights up based on that. They were allegedly promoting it for use as a electroretinography is what they were using it for. And that's when you put the electrodes either on your eyes or around your eyes and you're measuring retinal reaction to visual stimuli. So different anatomical location, different intended use. They didn't have clearance for the ERG, I think it was called ERG, electroretinography. And then they also had thrown in that Diopsis had made some modifications to their vision testing system that should have had a 510K, but they failed to submit and get clearance for the modifications. So that was also raised in this settlement. But essentially, they were encouraging providers to use it, allegedly, for this different indication. And again, it was a qui tam case, so one of the doctors who presumably had heard or seen kind of that communication. So yeah, they settled for $14.25 million. Dr. Jane, the whistleblower, gets $207,000. Really, the takeaway is we are seeing, again, kind of more, we've seen a number of off-label cases prosecuted under the False Claims Act. So promoting devices outside the use, that's a risk from a False Claims Act perspective. All right, next one is Assertio. So this is a drug company. They have a fentanyl nose spray called Lozanda. So they ended up paying, this was a qui tam case. It was two former sales reps, I believe. And this was just recently announced this month. They ended up settling for $3.6 million, but the key allegations were around practice development and targeting high-volume prescribers with their marketing efforts, so kind of strategically marketing certain high-volume in their area. And then they also did add that some of the customers were actually flagged for diversion or indicted, so there might have been something else going on, but this didn't cover those. This is an opioid, so it's kind of, taken with a grain of salt, but they essentially the settlement allegations were related to marketing, promoting off-label use. So the drug was approved only for breakthrough cancer pain and a certain population of people that were opioid tolerant and still needed some pain relief. And the allegations are that the company had kind of engaged in this program to increase the prescribing of off-label Lozanda. So again, takeaways. I should mention too, this also involved speaker programs and advisory boards. So they were selecting their high-volume prescribers to be on these boards. And again, focusing kind of practice development on those high-volume prescribers. Takeaways, again, off-label marketing, especially for opioids. I think we've seen kind of a definitely higher level of scrutiny being applied. So when there's patient safety or public health risk, there's going to be higher scrutiny. All right, Prometheus. So this was actually a DOJ-led investigation, so not a qui tam. It was announced in March. Prometheus is a medical device company. They manufacture pelvic floor therapy systems that require rectal pressure sensors and catheters. So they help with urinary and fecal incontinence. And these components, so they have kind of a system that they use for rehab. And the components were FDA cleared as either single use or single use only, meaning that they shouldn't be reused. However, the government has alleged that for a period of time, the company encouraged healthcare providers to reuse the devices by placing condoms or gloves over the catheters and the sensors to reduce costs. And I mean, in the IFU, it was sprinkled all throughout, like single use only, biohazard, do not reuse, but they allegedly were encouraging the use, multiple use, which is a little disturbing. And because that would result in lower overhead they wouldn't have to buy as many. And then Medicare was then billed for these treatments, so that's where the False Claims Act liability comes into play. Again, safety, when there's a safety issue, that's always gonna, again, get higher scrutiny from the DOJ. And here, clearly, there is a patient safety risk here. These devices are not intended to be used for multiple patients. That's a biohazard. So we'll just continue to kind of see, we continue to see safety cases where the patient safety is at issue to be on the chopping block, so to speak. All right, and then I will pass it over to Katy. Oh, geez, we have 5 minutes left. Pass it over to Katy for emerging False Claims Act risks.
Perfect, and I will be short and sweet on these. So high level, we are seeing additional scrutiny related to both genetic testing and telehealth. So in this context, we have 2 entities, GenX and Emerge, and also 2 executives who have agreed to pay $6 million to settle FCA claims over kickback-tainted genetic tests. So the allegations include the two entities, GenX and Emerge, which are Emerge being the parent company, as well as their CEO and COO, were accused of orchestrating a scheme where claims were submitted to Medicare for genetic testing that was collected by non-medical individuals in a non-medical setting, sometimes shopping malls or community centers. The samples were then sent in and prescriptions were obtained after the fact. In this context, the genetic testing was related to cancer genomic and pharmacogenic tests that were deemed medically unnecessary. Further compounding the issue, they're billing Medicare over $6,000 for these tests where patients were essentially asked in a shopping mall if they would be interested in the genetic testing.
That's right.
So in this context, the defendants agreed to pay $6 million. Additionally, for whistleblowers who brought the fraudulent activities to light were awarded $1.3 million. So again, another key TAM case, underscoring the importance of vigilance in healthcare billing practices. And our takeaways here are, DOJ is focusing on genetic testing fraud and telehealth abuse, particularly post-COVID. We want to make sure that these areas where there are more opportunities for abuse are being controlled and reviewed. Compliance risks for labs and marketers using commission-based models are also an issue. In this context, Emerge was the marketing entity, and GenX was being paid a portion of the proceeds from each bill submitted to Medicare. And then we have a Medicare Advantage in focus. So in this case, the allegations include entities such as Aetna, Humana, and Anthem paid disguised kickbacks to brokers of health insurance to push seniors to higher paying MA plans while claiming to be unbiased. So in this context, DOJ is stating that these brokers are intended to be neutral and help Medicare beneficiaries find the plan that works best for them. And they were creating methods to push patients to higher paying MA plans, and also working with these entities to push patients with disabilities to specific plans or not enroll them at all. So there is also a component here of discrimination related to those individuals' disabilities in an effort to keep costs down for the healthcare entities or the insurance entities. So we have false certifications in these MA contracts. We have CMS discrimination rules at issue as well. Why this matters is because we can see DOJ intensifying focus on Medicare Advantage in addition to traditional Medicare programs. This case bridges AKS, False Claims Act, and also civil rights enforcement. Again, another key TAM case in May of 2025. This litigation is still ongoing, but again, further pushing to ensure that we have compliant billing and coding for our.
I do want to mention the quotes from the emails.
Yes.
They're juicy. So in the press release, they had noted specifically and gave a few quotes, but there were some internal emails showing that they were aware of the non-compliance. This payment model is not even a little compliant, was one of them. And then the other one was, CMS will never figure that one out.
Yep.
Luckily, the government are generally morons. Like, who writes that down?
Executives joked in emails about CMS being too dumb.
Yeah.
Yeah.
Like,
So
okay, they need some write it right training.
Yes.
But anyways.
A side takeaway.
Yeah.
Right smart training is
Don't
also.
put that stuff in writing. With that, I know we're right at time. I'm not gonna, this is kind of a summary of everything we've talked about. I wanted to leave a minute or two for questions. Otherwise, we will be around for the rest of the afternoon if you want to catch us and chat later. Happy to do that. Any questions? We don't have any questions. All right, good. Well, thank you guys.
Thank you.
Thanks.